Good afternoon, folks. This is Darin Coble. I'm the founder of Versa Business Partners, a consulting and coaching firm out of Magnolia, Texas. We started this webinar series back about a month ago now to help connect small businesses with the experts out in the field. And it started out as a time when there weren't a lot of answers out there. And what's been pretty cool over time is to see as the laws are being made and all the decisions are being made, the Department of Labor, the Small Business Association, some of the larger public entities that are out there coming out with the resources that we need to answer a lot of these questions. But they're also offering, as I've seen, and you may have seen on the website, a lot of webinars like this one that will answer some of these questions. What I wanted to do was just, as we've received questions over the month, we've gotten inquiries on what do I do about EFMLEA or about the FMLA regulations? What do I do about managing performance? And so I'm going to tackle some of those questions today. And then next week, we're going to, or actually, I'm sorry, on Thursday, we're going to have someone from Employer Flexible, Mark Groves, who's a risk consultant, come in and talk to you about some of the HSE considerations, the health and safety considerations, as you're starting to reopen. You know, some businesses are going to be reopening on Friday. And so it's pretty cool. But it's not without risk and not without considerations to make as it relates to keeping your folks safe. And we'll talk a little bit about that today, but Mark Groves will hit a lot of the health and safety concerns and considerations on Thursday. So be sure to register for that one if you haven't. I want to thank Brian, College Station Chamber of Commerce, the SBDC, Employer Flexible for helping us kick these off. Just as a note, we're going to start evaluating the frequency as we're starting to see, as I mentioned, the Department of Labor and the Small Business Association, the SBDC, especially the Gulf Coast Network. They're really stepping up their education campaigns on funding, on the emergency injury disaster loans, on the PPP, and on those kinds of things. And so we may start shifting to one webinar a week, and slowing down a little bit on our end to highlight some of the other resources that are out there. So today we'll be talking about the EFMLEA and as well as the emergency FMLA regulations and some considerations that you need to think about as you're about to get started and kind of reopen. With that, we've got Jennifer Davis is on the line with me. She's muted and hidden right now, but she may step in. She's the sales consultant with Employer Flexible, and they offer professional employer services where they can employ your folks and kind of do all of your back-end HR stuff. And that way you don't have to have an HR department. So she may step in to help answer questions, as she's well-versed in this as well. So thanks for joining again. I'm Darin Coble. I'm a principal consultant and executive coach, and then also the founder of Versa Business Partners, and grew up in a corporate HR environment, working in manufacturing. Started out second shift of a manufacturing floor, doing HR for second and third shift up in northern Minnesota, just south of Canada, with Polaris Industries. So we were making snowmobiles and ATVs and Rangers and Razors and those kinds of things, and bounced around different industries, and got to a point where I was leading an HR team and decided it was time to step out on my own and kind of chase this dream of consulting and coaching and helping leaders kind of serve their people. So as we get going, we'll start out talking about the laws that are in place. And so with COVID-19, as the regulations started and were passed in March, you ran into one main law, which is the Families First Coronavirus Response Act. And so this act is basically what encounters and covers all of the emergency paid sick leave and the Emergency Family Medical Expansion Act. And so the Families First Coronavirus Response Act is what covers that. The critical thing to remember about these three, as I'm talking about them, it's confusing. And so as a business owner who may not be well versed in FMLA because you've never had to worry about it, I'll try and give you an idea what to think about, but don't get overwhelmed as you're going through this. I'm available for phone calls, for emails. If you have questions after this, please don't hesitate to reach out, and I'll try and help you make sense of this as we go. The Families First Coronavirus Response Act, the FFCRA, became effective on April 1st. And so we've seen some mixed regulations out there, mixed practice on when the leave should apply. And so if someone got sick in March or had some issues in March, does this apply to them? Or if you laid them off before that, should you have applied it to them? The quick answer is no, it shouldn't if it happened before April 1st, but the litigation answer as far as what the law and how the practice is going to be has not been decided yet. So if you run into anything that a claim is made before April 1st of a leave request or something that happened before April 1st, you want to make sure to kind of get some consult and some advice on that of how to handle that. This is in place through the end of the year, through December 31st. And so these laws are going to need to be maintained and monitored at least through the end of the year. The Department of Labor is the governing body that is in charge and regulating the laws, and their wage and hour division is the group that would be notifying you if someone makes a claim or would be getting a hold of you. And they're the body that's been evaluated or tagged with taking care of this. The one thing to note on this is, as you're bringing employees back into the office or back into your work setting, there is a posting that is required. And so at the bottom of this page, we'll send the slides out after the meeting, but at the bottom of this page is the website where you can go and download and print the posting off. It's a one-page document that just says employee rights, and it's actually a great resource for you as the employer to look through and understand what's required of you. And so I'll actually download that PDF and we'll send it out. Jennifer Davis from Employer Flexible will send out a thank you email after the webinar, and I'll make sure that that posting is there for you as well so you can print that off. As you look at what the FFCRA is, it's basically the large umbrella. And then there are two laws under that group that are important for you to pay attention to. The Emergency Paid Sick Leave Act, which is basically indicating that as an employer, if someone requests leave for a certain reason, and there are 6 different reasons we'll talk about, then you're required to provide 2 weeks of sick leave pay. That pay it's variable based on the situation. So it's a different amount based on each situation. And it is a 2-week period. Now, it can potentially move into an additional 10 weeks if your employee is requesting this for childcare reasons, say their school's closed or something like that. And there is a potential exception allowed here that I'll talk to in a little while. But for this reason, for that additional 10 weeks, if you have less than 50 people working for you, then you may be exempt from that additional 10 weeks for that reason. I'll do my best. It's pretty confusing how they've broken this out. Again, we have 6 reasons that we'll go through, and one of those reasons will kick in that 10 additional weeks for childcare. And so the core thing to remember is the base of the coverage would be 2 weeks of sick leave pay. And then as it goes into the additional pay, I'll go through that reason in a minute. The next act is the Emergency Family Medical Leave Expansion Act. And so the Family Medical Leave Act, FMLA, was generated years ago and put into law in order to basically protect people that got sick or were going to be absent because one of their immediate family members got sick. So let's say that I got sick and I was going to miss a bunch of work because of a major illness that required me to be out for continued medical treatment, or I missed 3 or 4 days of consecutive work because of a major illness that requires me to continue to go to the doctor. And so the Family Medical Leave Act came out, FMLA came out to say, well, you shouldn't be able to be fired if you meet certain restrictions and certain bars of requirements if you get sick, or if your mom or your wife or your husband gets sick and you've got to take care of them. And so oftentimes those considerations for Family Medical Leave Act were you have to be employed for 12 months with the employer and you have to have worked so many hours during that time. What the Emergency Family Medical Leave Expansion Act has done is it has expanded the FMLA requirements to smaller employers, possibly like yourself, that also have just not been encountered before, and so, or have to encounter that before. The protection, because of COVID-19, the government wanted to come in and say, you're not, you're protected. You have protections out there if you were to catch COVID-19 or someone in your family did, or you had an impact because of the pandemic. And so what they've done is they've just expanded family medical leave to essentially all employers that have 500 or less employees. So they expanded FMLA and put a little bit of a tighter restriction on the smaller employers at this point, in my opinion. And so as we move into that detail, let's talk about who this applies to. And so as you're sitting back and looking, recognize that there are a couple of different groups that we'll think about as we look at this. You have the public sector, which is basically, well, actually, I think that should say private sector, basically any company out there that's not doing government work or isn't a federal contractor. And then you have your public agencies like your federal contractors or your federal government employees. And so if you have less than 500 employees, essentially these laws would apply to you. And if you're a non-for-profit, this actually applies to you now as well. So from a public agency perspective, if you're a government agency and you're on the phone and listening, then it doesn't matter how many employees you have. This is going to apply. Now, for the public sector, as I mentioned, there is an exception that I'll talk about for those employers that have less than 50, and we'll talk about that in a few minutes. One question that's come up pretty frequently is, how do I count my employees? So if you're at kind of a cusp of that 500 mark, or you're at the cusp of the 50 mark for the exception, how do you make that count? And so one thing to keep in mind is it's only counting the US-based employees. Now that excludes folks in District Columbia or some of the territories that are out there, but it should only count your US-based employees. It does include all full and part-time employees, and it includes those that are working or on leave. Your temporary employees and day laborers through a temp agency are actually going to apply here. And that's a little unique to think about. Now, when you have to do the count and you've got to do your count of how many employees you have, does this apply, does it not apply? You're gonna do it at the time of each leave request. So at the time that the person puts in initiates a request of leave, then that's when you've got to do your count. And so I would make sure if you're doing that and you're on that cusp of between the say 50 to 40s to 50s, or 500 400s to 500s, you want to make sure that you're documenting that count as each leave request comes in. Note that this doesn't require any significant documentation for the request. And so if someone says, hey, I need some help, I've got to take care of Johnny, his school's closed, and I'm the only one that can do anything to teach and take care of him during this time, then that's essentially going to count as the request. And so you've got to make sure that you're working with your managers, your supervisors of people, so that they're documenting. And when I say document, I don't mean some big note or document of a formal form. What I mean is basically, I'm okay typically when I work with clients to just, as long as you've got a record of the call or a record of the request, but you want to make sure you know what was asked for, what time it came in, and what day it came in, because that's going to be kind of your record in case you have to go forward with any further information and you get into any litigation or anything like that. Just a reminder, I'm an HR consultant, so I've got 20 years of HR in companies ranging from 20 to 100,000. And so I am not an attorney, but we do know some really great employment attorneys that are in the College Station area, and Bailey Rhodes would be one I'd point you at. And then in the Woodlands area, we have Lee Freeman that's around as well, and they're great resources. For the reasons that we've talked about, there are 6 reasons that the government has said an employee can take leave related to COVID that would be protected by these laws. And by protected, I mean you can't terminate them because of it. You can't hold it against them from a pay perspective in terms of, well, you know, you had to take leave off, so I'm not going to give you a raise this year. Anything that would seem as harmful to the employee as it relates to their employment relationship is prohibited by these laws if they take the time for these reasons. And so if they're unable to work or telework because they're either subject to a quarantine and isolation, and so that it's related to COVID-19. So let's just say that they've been told, well, you're in contact, and the government says you are in isolation and need to be, you know, isolated from other people. That's level one. Number two is if a healthcare provider has basically said, yeah, you know what, you went to Louisiana, you crossed back over, and we need you to, you may not have it, but you better just kind of stay home and self-quarantine. And so stay by yourself for the next 2 weeks. If a doctor regulates that or asks that, then that's what would count as reason number two. And remember, depending on the definition, if they're able to do telework, you know, that's where it gets kind of sticky, because if you're going to have to really gauge, okay, well, you're at home, but you've got internet, you've got computers, we've provided all the tools, then I don't know that this would apply to that. And so you've got to make sure you're gauging each situation carefully. If the employee is experiencing symptoms and seeking a medical diagnosis, so let's say that they say, look, I can't work today because I've got to go to the doctor, then that would cover them because they think they have COVID-19. Well, I've got a fever, I've got a headache, and a sore throat, so I'm going to go get checked out. You can't hold that against them as say, I'm going to fire you because you've missed too many days. Well, you're just not able to do that because of these regulations. If they're caring for an individual that's subject to an order described in number 1 or number 2, so let's say that they have someone who has been quarantined that they're providing food for and care for and feeding, then that would be something that would allow them, and that's where the family care comes in. The number 5 is the sticking point for most folks right now. If the employee is caring for his or her child whose school or place of care is closed, or the child care provider is unavailable due to COVID-19 reasons, then they're entitled to request a leave. Now with that, it gets pretty gray on the definition of, does it apply versus does it not? Are they a single parent? Are they involved? You know, do they have any other additional support structures? Those are things that you've got to kind of, you rely on your leadership team. And I recommend talking to either a consultant or to an attorney about how to move forward on this one. Number 5 is the one that I mentioned. If you're an employer with less than 50 people, less than 50 employees, then you could be eligible for an exception here. And number 5 is also the one that kicks in that additional 10 weeks of pay. And I'll talk about the pay levels here in a second. And so just as you're thinking through that, that's the one that you're going to want to kind of keep front of mind. And when you're training your managers and your leaders, that's the one that you want to make sure that they're kind of keeping their ears open for and understanding. And their relationship with their employees is what's going to help you make some of these decisions. That, or as for those of you that have worked with me, I see some folks out there, you've probably heard me say, you know, sometimes you just have to have a frank adult conversation. And that sometimes means just asking some tough questions to really get a good gauge of the situation. Number 6 is experiencing any other substantially similar condition by the U.S. Department of Health and Human Services. And so with that, you come into kind of the ADA laws and some of those details, but that's just to kind of cover the other possibles. So be it flu or something like that, that may come into play. So on the handout that we'll send out that the Department of Labor has put together, this is actually a screenshot of these reasons. And so again, the handout will provide this information pretty clearly for you that the Department of Labor put together. And that handout, again, is a posting that you need to post. And if you haven't sent it out to your employees, if they're teleworking, I would recommend sending it out as well, just so that your employees have access to it. So this is where we're going to get into the amount of money that's required to be paid. And so, as I mentioned earlier, the base pay required is up to 2 weeks of pay. And so if it's a full-time employee, the assumption is that that's 80 hours. If it's a part-time employee, the guidance is to take, if you can, the last 6 months of wages and average those. Let's say they went from full-time to part-time and within 3 months from then you may just take those 3 months that they were working a part-time and average that out. But that's your base calculation, is 80 hours, or if they're part-time, you're going to want to look at what 2 weeks of their average pay, their average hours would have been. And so here's where it gets really confusing. And I'm actually, if I can figure out how to go backwards on the slides, I'm going to go ahead and move backwards and forwards. And so for those following along on the video, just hang with me. But if it's reasons 1 through 3, you're going to pay 100% of the pay up to $511 daily, or up to $5,100 total. And so if you remember, this is 100% at $511 daily up to $5,110. 1 through 3, subject to the federal state quarantine. So they've been told that they're required to quarantine and isolate. If they've been advised by a healthcare provider to self-quarantine, or if they're experiencing symptoms and they're seeking a medical diagnosis. That will require you to pay them at 100% of pay, up to $511 a day, or $5,100 total for the 2 week period. If their qualifying reason is number 4 or number 6, or number 6, then they're eligible for 2/3 of their pay. And that would be up to $200 a day and 2,000 totals for that 2 week period. And so again, number 4 and number 6, if they're caring for an individual that's subject to a self-quarantine, is described in number 1 or number 2. So if they're doing the care and feeding of someone that has been defined to have to self-quarantine by either a healthcare provider or the state or federal government, then they're eligible for 2/3 of the qualifying reason for pay. And then also number 6, if they're experiencing any other substantially similar condition. And so if it's a similar illness, and the U.S. Department of Health and Human Services, I have not seen full examples of that yet, but that's where you would have to pay 2/3 for the qualifying reasons. And then lastly, as I've talked about, number 5, up to 12 weeks of paid sick leave. So this is someone that is caring for his or her child, or whose school or place of care is closed, then that may be up to 12 weeks of paid sick leave. And that again is at 2/3 up to $200 a day, or 12,000 total. And so that's the one that's the sticking point. Again, if you have less than 50 employees, you are potentially eligible for the exemption that removes the requirement to pay them for 10 weeks. The government's going to want to understand, like, if you were to get charged with a concern, or an employee were to call and file a complaint with the Department of Labor, the government's going to come in and they're going to look at it and kind of say, all right, how much capital did you have on hand? Meaning, how much money did you have in the bank to pay the employee? How much impact to the business was this going to be if you took a negative action against this employee, if you couldn't continue to work at that time? Those are the types of questions they're going to ask if someone calls and complains and files a complaint and requests an investigation for this. From a part-time perspective, they're basically eligible for whatever their normal schedule allocated or allowed. So let's say they were part-time and they would work 20 hours one week, 30 hours the next, and that's what you had them scheduled as. That's what you would normally pay them for. And so you just need to look at your history and be able to provide documentation and justification for how you calculated this out. And so, again, reasonable discussions and reasonable decision making with the evidence kind of in hand will help through this process if in fact you were to get into an investigation or to get sued. My recommendations as you think about what the heck do I do here? How do I protect myself, and how do I make sure that I'm treating the employees how I need to? But then also, how do I prevent or protect myself in terms of a potential litigation? So as I mentioned this, I mentioned that if an employee were to call the Department of Labor and file a complaint, or if the employee were to sue, there has been a handful of lawsuits that have started to pop up where employees are saying they were either terminated without cause, or they were terminated and it's a violation of the FFCRA and the subsequent laws. And I think it's important to kind of pay attention to those as you're out there making decisions as it relates to performance and determination. And so we'll go into a little of that information here in a second. But the critical piece, and one of the cases that I've seen, is that the employee was talking to a bunch of different people. They pretty much called anyone on the leadership team that they could get a hold of and had conversations. And we're hearing one thing from one leader, another thing from another leader. And so this is important. The reason for that FFCRA expert is that you have kind of one person that's able to be that point of contact for these types of inquiries as it relates to people wanting time off or needing to take some time off, or needing some protection as it relates to the COVID-19 pandemic. And so you want to understand the key information, the key answers and key questions, some of the things we've talked about today, but just how do you plan to respond? And you want to train all your supervisors of that so they know how to get into touch with the FFCRA or whoever is kind of that one point of contact that can make sure that you guys are handling this without discrimination and with consistency. Then you also want to make sure that you're communicating. And so you want to make sure you're communicating across the board, either through, whatever works best for your workforce. But you want to make sure you're communicating what your expectations are and what you're doing. Now, that being said, if you have performance, or if you result in something that is a termination, that you're terminating someone for, this is a good time to document and deliver in writing. Now, I encourage you, if you're going to document it and deliver it in writing, get a review, get somebody that's familiar with kind of case law and those kinds of things. So an attorney, if you were to call me, as if I were your HR consultant or your HR person that you had hired, I would put together a letter for you, but my final instruction would be, look, I can get this reviewed by an attorney I know, or you need to get it reviewed by an attorney, just from a gut check perspective. But basically, you want to make sure you're documenting the reason for the termination. And some of what I've seen in the past is we've done this, and we've put the reason for termination in there. It's to clarify exactly why you're terminating them. And the reason you do that is so if they go to talk to an attorney to say, I want to sue my employer because they fired me for the wrong reason, that the attorney's going to say, well, did they give you anything? What are the reasons? And that way the attorney's going to be able to ask a bunch of questions of their potential client that they're going to be representing on why it is that they were terminated. And that letter will provide if they were belligerent, or if they had a history of performance concerns leading into this situation. It helps provide a preliminary or a preemptive defense. It also helps to just document the reasons and get that in writing in case you were to get a call from the Department of Labor asking what happened there. You at least have documentation that helps support that discussion. So as you move into the FFCRA and the FMLA expansions, it's confusing. I've tried to simplify it as best I could for a short conversation like this. Again, I'll be able to we'll send the slides out, but if you run into questions or clarifications or what do I do here, we're going to be able to take questions. Go ahead and send them in if you want, over the chat or over the Q&A box. And I'll answer the questions I can, and those that I can't answer, we'll research and get back to you as soon as we can, and put you in touch with the right folks if we need to. So now that the governor has come out and said, all right, folks, we're getting back to work, Texas is opening back up. There are some things that I would recommend you start thinking about. And you didn't get I don't know how much time you've had to really even settle down and think through this. But as you're getting ready to go back to work, I think it's important if you can pull your leadership team together, or pull some of your key employees back together and talk about what the plan's going to be to come back. There are some federal and state requirements to think about. Texas actually has a checklist for employers that talks about the things that you're required to train your employees on if you're bringing them back to work. It includes, sanitation practices and those kinds of things. And so I'll include at the end of the presentation when we send it out, there's a link to that website that the governor has put out there that the task force has done for the state of Texas. But you want to make sure you're taking into that account so that you're at least providing all the training required and what you need. You need to think through, who do you really need to bring back on the first day or on the onset, and stage your return back. As folks are also going to be trying to figure out, what do I do? I had this going on for so long, and now I've got to figure out how to shift my routine back. And so you want to make sure that you're able to plan that out accordingly and communicate it as you go. I would recommend you think about the what ifs. What are you going to do if somebody refuses to come back to work? And now, you know what? This telework thing is awesome. I don't need to come back to the office. How are you going to handle that? And as a leadership team or as an owner of your business, you need to think through what you're going to do there and think through the requirements that you're going to require. And as you're making those recommendations or you're making those decisions, you want to make sure you're avoiding different types of areas that could be perceived as discriminatory. So it could be race, it could be age, it could be disability status, veteran status, different types of things that someone may, while you had no ill will or bad intentions, they may say, well, you know what, you're doing that because I am this. And you just want to make sure you take that into account. You have kind of a good practice and decision-making strategy as it relates to who you allow to continue to telework and who you don't. What do you do as an employer if someone comes into your office or comes to work with COVID-19 symptoms? How do you handle that? What's the protocol? And how do you make sure you train the employees? What if someone comes in and actually went and got tested and they come back positive? How are you going to handle that? What's your communication strategy? Have you thought about the HIPAA laws, and so that you're not communicating who it was that came down positive with it, but you're also communicating well enough to protect your employee base? And so once you kind of get those types of questions answered, and you want to start to document those and make sure that you have several folks that kind of understand the different plans and are able to kind of serve as a secondary support. So you want to make sure you don't have a single point of failure where you can protect that from, because if one person were to get sick when you're back in operation, you want to make sure that you've got either the documentations, the notes put together on what to do and how you're going to do it covered. You also want to think about, from a policy standpoint, policies to update immediately. I wouldn't say that that's your top priority is to get it. As long as you've got your plans documented and your procedures, I think you're going to be okay. But you want to think about what policies, as things have changed and you're moving forward, what policies are you going to consider? Maybe you've decided this telework thing works great. Well, if you don't have a telework policy, you may want to think about putting one together down the road. And then you want to, once you've got your plans, procedures, and kind of how you're going to respond, you want to make sure you do training. Train the leaders on establishing communication and how they're going to do that. Train on who's responsible for what, and work through those details. And then lastly, you want to make sure you're communicating. So get your communication plan established. Make sure you've identified who your stakeholders are. As you're thinking about, you're the owner of the business. If you've got an HR person or you've got a health and safety person, make sure you're including them, because they can help think through where the gaps are and what's been required by the agencies, by the state and federal government, to say this is what you need to communicate, and this is what you need to train on, and this is what we need to think about. And then you've got to think of your employees as a stakeholder. So what are you communicating to them? How are you communicating and making sure that your teams are getting the same message, and that the message is applicable where they need to? And then also, what's our messaging to our suppliers, to our contractors that are, you know, they're not our employees, but we use them for XYZ services, to our vendors, and obviously, and also to your customers. What types of things from a customer standpoint do your customers need to know? If you're a retail business, what types of things they need to know as it relates to what you're letting in, and, you know, who you're allowing, and capacity, and those kinds of things. But as much as you can, in the middle of trying to get ramped back up and get ready to turn the revenue stream back on, or ramp the revenue stream up, the more time you can take, even if it's just an hour, pulling your team together and saying, all right, folks, what do we need to do and what do we need to think about? And let's at least get the plan of the who, what, and where, you know, or when. Who's responsible? What are you responsible for? And when are we going to do that? But the more you can do that, the early on, the better, to help streamline your ramp back up. Another question I've received as we've been going through this process is, how do I manage performance? I've got an employee, they've been a problem for a while, or their behavior's not been where it needs to be, their performance has not been where it needs to be, and this has really exacerbated that. And the answer is yes, you can still manage performance during a pandemic. The key things to think about is, number one, don't discriminate. Make sure that you're not making decisions as it relates to a protected class. That aside, the things that I recommend, and the questions that I would recommend you ask as you're looking to manage performance is, you know, have I communicated the expectations clearly? Does the employee know what's expected of them? Answer yes. All right. Well, have I corrected it when they're not doing what they need to be doing? Well, yeah, I've talked to them 4 or 5 times. Okay. Do you have any proof or documentation? Again, as an HR advisor, I am not a stickler on having a written corrective action form that spells out, on this date I met with you and talked about this. I am a fan, and your attorney may tell you otherwise, but I am a fan of having an email, if they're a professional employee and they've got an email account, saying, hey, listen, I just want to revisit on our conversation we just had. That to me is a great piece of documentation to say, not only do we communicate, but I followed up. A notebook that you keep you track and log your communications and what your talking points were. That to me is kind of what I mean by documentation, that if you need to be asked at some point, did you talk to this person about this? Well, yes, I did actually. On this date, I spoke to them. Well, how do you know you did? Well, my notes here show. Are there any external factors to think about? You know, this is one from a human perspective and from a people perspective to always just kind of take in mind. You know, you don't want to get into a situation, and maybe you just have to, because it is where it is, and you make the decision that I've got to drive change here. But a lot of times right now, the world's under a lot of stress, and so just kind of take into account what's going on with them and make sure that you, as best you can, have supported the employee where they needed to, and that this isn't just a blip on the radar of their employment. And if you're nearing termination, one question I always like to ask folks is, do they realize they could be fired? And you know, when I've been in meetings with supervisors, it's one of those things where I've tried to make sure the leader has prepped the employee to say, listen, if this behavior isn't corrected, you're going to lose your job. And just making sure they understand how close they are. And so those are some questions to ask yourself. You may ask yourself these questions and think, no, you know what, I haven't communicated clearly, and no, they haven't corrected, but by gosh, they should know better than to try and jump a forklift. Okay, yep, I think you need to go ahead and terminate. Those are the types of things, but these are great questions to have as you're going forward in any situation, but especially as you're looking through the pandemic situation. From a termination standpoint, if you're going to terminate someone, again, keep in mind the discrimination. You know, some of the common reasons for termination right now are lack of work or capital. I just don't have enough money to pay these folks. And so, you know, you're going to probably respond to that with a furlough or a layoff. You want to make sure that you're looking at your numbers and looking at the demographics of the folks that you're laying off to make sure you don't have any adverse impact where one population is getting laid off more than another. It's the best you can. There are calculations out there that'll guide you through that. Performance, as we talked about, just make sure you're setting the clear expectations and communicating. And then from an absenteeism perspective, if you're terminating someone from absenteeism, you want to be really careful. Make sure you're getting a third party, or you're having someone review it for you, or you're at least taking a look at it to say, okay, how much exposure do I have to the FMLA or the EFMLEA related absences. So how am I doing what's required of me as it relates to the laws and regulations around the COVID-19 pandemic, as well as just absenteeism as a whole. And then my last piece of advice that I provide, that I learned at my last job from a senior leader, was, is this employee going to be surprised? So if you're getting to a point you're going to terminate someone, you want to make sure you understand, or at least you have an idea of, will this employee be surprised that they're being terminated? And that's where those questions come into play that I put on the previous slide. Is, has your leader, or have you done what you needed to do to make sure this employee understood that this was coming? Again, there will be moments that, yes, I've talked to them 100 times and they really just don't understand it, and yes, they're still going to be surprised. But another reason from that surprise piece too is it helps you to do some risk management as it relates to having that conversation with the employee. It helps you to stop and say, gosh, okay, they are going to be surprised. And then you'll go into some risk discussions of, is there a risk for violence or anything like that that could come back? And so those are the considerations that I'd recommend you kind of think about, you look at, and as you're going into terminating an employee, just work through it. And if you have questions, feel free to give us a call, or your employment attorney, and just make sure, when in doubt, get a second opinion and walk through it. So I've seen that we've had some questions come in, and we'll go ahead and start answering some of these questions as they come in. Again, you're welcome to write your questions in the webinar chat box or in the Q&A box. And so the first question is, can you keep 6 employees over 65, I assume that's by age, from returning to work, since the governor has a separate plan for over 65? And that's a good question that I remember reading, that there is a potential exception there, but you could still run into a potential discrimination claim just because of the age. And so I'm flipping through now my notes to see where that exact statement was. And Jennifer, if you're on the line, if you've got an answer to that, feel free to pop in. But I would caution anyone from just doing that. I would work with that employee and kind of understand what their thoughts are, if they have concerns, and work through it. But as it relates to over 65, there was one question specific that I had seen that too. One second, I apologize.
That's one of the first steps that we take with our clientele. Fairness, we actually start by making sure we have a full understanding and the scope of the situation before deeming an end result. I do think there was one, I was actually trying to look in mine as well. There was one question that was addressed on that. If we can't get a clear answer, I will make sure that we get that sent out promptly if for some reason it's after we end the webinar. It's a great question.
Yeah, and what I found is the CDC has identified them as being a greater risk, but it doesn't necessarily justify a secondary decision. Now, the research that I've done, and the question I was remembering was, that was based on if you were going to postpone a start date or withdraw a job offer, if you wanted to pull the offer back. I think that you would be okay offering telework if you've been doing telework. And so as long as the employee is amenable to that, and if they're not, I think you just kind of work through your concerns and have that discussion as it relates to it. Having them work from home and telework is not an adverse, is not something that's usually going to be defined as an adverse employment action. And so I think you just have to kind of gauge that. If you're not paying them, I think that's something to evaluate and look at. And that is one that Jennifer and I will kind of look into to understand the answer to that one. But that's one that I would probably say, you know what, let's find out what case law shows, and let's take a look at the details, and we may need to call an attorney on that one. But with any of these questions in any of these situations, the one thing that is very difficult is you're dealing with humans, and that means that you have a new variability for each interaction that you have. And that's where, for the questions about over 65, that's where, you know best this employee, or your leader of that employee knows best kind of how that reaction is and where that risk is going to be. Some employees, there's going to be minimal risk to have a very frank conversation of, hey man, if you don't want to come back in, I get it. We've got some work for you that you can do from home, or let's see what we can figure out how we handle it. Other employees, it's just too high risk to do that. And so you're going to want to document and understand how to go forward. Great question, though. Another question, I have employees that took time off to care for kids that were concerned about risk of contacting CV-19. Most were out about 2 weeks. As business started picking up, we requested that they came back to work, and we were told that they no longer wish to work. Are we still subject to the laws? And I assume by the laws, you mean paying them for those 2 weeks. For that reduced pay, you can require them if you offer sick time or vacation time. Any of you can require that, or not require, but they can use their time to fill that to get to 100% pay. As it relates to if they quit, I think you're going to want to get a good document saying that they resigned and that they no longer wish to work. But the challenge is the Department of Labor could come back and say, well, they technically were employed through that 2 week period. And so with that, you're still required to provide that coverage. And so my strong answer, kind of risk averse answer, would be yes, you're subject to those laws and you need to pay. Is it something that you're going to be held tightly to? It's too early to tell how the Department of Labor is going to respond. And so I would, I think you can kind of take a chance if you wanted to, but just know that if the Department of Labor comes back, there could be fines involved and legal fees in the response and those kinds of things. So you've got to kind of gauge and do a cost benefit analysis of what it's going to cost and what the risk is going to be. But the furthest right answer to that question of my employees were out 2 weeks to watch for their kids, do I still have to pay them when they quit, when they came back, is the risk averse response is you're probably better off just writing the check if you can afford it and not having to worry about anything coming in the end. If money is a concern, a strong concern, and you don't have the capital to cover that, then you've got to make the business decision on how you handle that and just gauge it from there. So again, and I'm an attorney, the attorneys we had on a couple weeks ago, there's a lot of gray areas in this stuff. We don't know how the judges are going to respond and what case law is going to do. But you've got to kind of make the best decision you can and just be comfortable with that decision to see. But that's a question that I'll follow up on as well to understand and get an answer out. Another question that came in is, could I have a wrongful termination or a lawsuit filed on me if I require employees to come back and they refuse? And the answer to that is, you could be sued for anything. And so anyone could sue you if you were to terminate them because they refuse to come back. I think what you've got to look at, and the typical things to consider in that situation, is telework available? What types of situations are they dealing with that they don't want to come back with to work? What types of concerns are they presenting? And if you offer a medical plan or a health plan, kind of what types of resources could you provide to kind of help alleviate some of those concerns? If they're a critical employee and you can't operate without them back, I think there's a chance to evaluate, the severity of terminating it because they're refusing to come back. You need to run those terminations again through that checklist as it looks through the EFMLEA or the FMLA and the FML Expansion Act, and evaluate those to see if they're falling under the classifications of any of those things. If that 2 week mark has passed for everybody except for those 5, or set for number 5, and if that 2 week protection has passed, then yes, you can terminate. But you have to be careful to just understand what their situation is, and that way, if they do sue you, you've got a documented response to go. But you could, if they've had their allocated leave of the 2 weeks, or the 12 weeks if it's number 5. How do I handle employees that are coming to work with emotional issues as it relates to fear of the COVID-19, of the coronavirus, or fear and just frustration or anxiety around the workload? So I think that there are a couple things to consider as you go through here. You might check with your benefits groups if you have a benefits broker, benefit plan, to see if there's an employee assistance program. They call that the EAP at most companies. And what that can provide is access through your health insurance if you offer it to public counseling resources. I have seen that there are some associations of mental health counselors that are actually providing free telephonic consult, and so you may evaluate that. But you want to make sure that you're having a private discussion with the employee. You may want to have two folks in the room with that, just to kind of, they're their supervisor, but to understand what their core concerns are and what resources you may have through the company. But ultimately, as the employer, you've got to balance the protection of that employee's rights, but also what you need to do as a business.
Darin, in addition to that, there are, just to kind of reinforce, definitely make sure you reach out to your broker or your benefits provider, because there is many companies that are now insourcing some of that behavioral health coverage through, June, July, even some of them the end of the year. So that would definitely be a source I would reach out to immediately.
Great, thank you. A new question: if we offered hazard pay or bonus pay for coming into the office, do we put ourselves in a position of increased liability that the employee may get sick and say that we knew it was dangerous? That's a great question. And I would argue that my recommendation, if you're in this situation and you're doing that, is that so long as you're applying the guidance and you're applying the guidelines that the states put out, such as the training that's required, that the governor communicated yesterday, that we need to train our employees on, appropriate distancing, appropriate sanitation practices, and those kinds of things, then I think you're covering yourself as it relates to the exposure and the risk that is there. Now, again, anyone could come and say, well, gosh, you paid me more to come in because you knew it was so dangerous. And I think what you might want to do as you're doing that is you probably want to think about how you're defining that pay and how you're communicating what that pay is and what the intent of that pay is to do. And so instead of, like, I would stay away from hazard pay. I would think of it as a temporary increase, because the return to work is so critical for us, and we need every hand on deck that we can. I would think about how you're documenting that pay and what the intent is to do. If you're legitimately paying them a hazard pay because they're coming into a higher risk or of exposure or whatever else, then you need to evaluate what you're doing to protect them and make sure you're doing everything you can to prevent infection and to respond. It's typical that higher risk jobs do make more money. And so the salary system and the compensation systems already account for some of that. But as it relates to this, I would just be careful. My recommendation is just be very careful on how you define what your intent is behind that extra pay and what you want to do. But yeah, that's a good question. Another question came in. Actually, this one is, how do we handle meetings internally once we're back to work? For example, vendors, how do we protect the employees and ourselves from exposure? So I think that's a great question. One of the documents that I've seen being updated is the visitors policy, and what you're doing as it relates to visitors that come in or customers that come in. And so it's just evaluating what you want. I've seen some other companies restrict entry and say that only employees are allowed in, and we're not going to allow vendors in at this point, or sales calls or any of that. And so I think you've got to gauge what you want to there, but I would make sure that you evaluate what postings you have and what the expectations are of someone coming in, and what you require. Mark, the risk manager for Employer Flexible, next week, on Thursday, we're going to talk about that a little bit more, of the types of things that they're looking at doing for eFlex and all of their employer flexible and all of their clients, and talk a little bit more about what types of things to think about. But you definitely want to protect your employees as best you can with policies, procedures, and guidance. And then actually we just got a recommendation here that says there's a great app that's out there. This is from the team at Tech Bundle that says it's business.checkins.app. And so I'll make sure that we get that one posted to all of the respondents, or all the folks that are on the call, so that you can see that app as well. But this allows you to track your employee screening and to track your information as these folks come in. And that's one thing we'll talk about on Thursday with Mark as well, is what do you do? Let's say you are doing employee screening. You want to make sure you're tracking those and those kinds of things. And as the Tech Bundle team, Stephen just indicated that this business.checkins.app does allow for HIPAA compliance as well. So it's a great app to look into. And if you have any questions on it, the folks over at Tech Bundle can help you figure out how to apply it to your business. So thank you for that. Well, I'll take, I think I've got one more question that we can take, and then we'll go through. With everything going on, I need my employees to come back in a different capacity. How do I address it if they say, yeah, that's not my job? It's a challenge, and I'm personally, I'm a little worried that we may have some of those concerns come back. You know, if you've furloughed employees and they've been on unemployment and they've been receiving the extra money, you may have some resistance there. And I think it's critical for you to, again, as they're coming back, document clearly what the expectations are, what the consolidation of work has been, and what types of things are going to be there. And then from a pay disparity standpoint, from a compensation standpoint, you know, one of my longer term recommendations for clients is that as you come back from this, and your organization is probably going to look different, your folks are going to be doing work that is different than what they left when this happened. And so as those consolidations happen, I strongly encourage taking a look at your compensation and your pay equity structure to make sure that you've evaluated the workload and the new work and the new skills that are required for these folks to do their job. Now, if someone comes in and refuses the work that you're offering them and that you feel they're capable to do, that can move into an insubordination situation, and a situation of, you know, look, our business demands this. This is what we're required given the team that we have, and I really need you to do this. And if they refuse that, then you've got to move towards a consequence as it relates to what's expected, and that could be termination. It could be, you know, reevaluating, you know, what they require. You'll know on your team what you can absorb and what can be handled. But you know, my hope is that everybody coming back and the workforce is just so excited to be back to work and to get going. And so my hope is that we'll be able to do that without a whole lot of this, it's not my job. But be prepared if it does come to, again, I go back to kind of that frank adult conversation of the business justification, understanding what the employee is concerned about not doing it. Is it a skill set gap that you can provide some training to help with? Is it, you know, amount of time in the day? Is it just a sheer refusal to work? So that you want to make sure you have that conversation and ask those questions. So, all right, before we wrap up, two things. Here's the website that you'll also see from a government standpoint. The Governor's Task Force website, that is where you can get your checklist that they put out there that you need to make sure you're training your employees on certain things when they come back. They actually, I believe, have a checklist for employees to consider as well. And so a great resource there for Texas employers. And then also from a Department of Labor standpoint, this slide will be in here, and I'll make sure the links are active in the document, but it also, this requires or provides you the posting that you need to post. And just note that the first link is for the employee rights poster for your private companies. And then the federal employees, in case you've got a federal agency on the line, this is for the federal employee rights. And then your frequently asked questions are also here that'll help you kind of understand how to handle these different types of situations. So, folks, I appreciate your time. please check out what we have online for next Thursday's webinars, and we're going to look at next week and kind of see what's coming. We've got a couple folks that have raised hands to be interested in talking, and we'll see what the schedule allows with what the Bryan Chamber of Commerce has going on as well. So special thanks again to you for attending Bryan Chamber of Commerce, Bryan College Station Chamber of Commerce, Employer Flexible, and the SBDC. And we'll talk to you on Thursday. Thank you all.